Okay, stream.
Yeah, there's a message.
Live stream starts.
Hello and welcome to the second lecture of the SCAORA lecture series organized by the Supreme Court Advocates on Record Association. Today's topic is professional ethics.
Yeah, there's a message.
Which is a...
Live stream starts.
am I audible to all? Hello and welcome to the second lecture of the SCAORA lecture series organized by the Supreme Court Advocates on Record Association. Today's topic is professional ethics.
Yeah, there's a message.
Which is a...
Live stream starts.
am I audible to all? Hello and welcome to the second lecture of the SCAORA lecture series. There's a lot of... There's a lot of echo.
Somebody has opened the YouTube link actually.
Am I audible to all? There's a lot of...
You can start now.
There's a lot of...
Right, sir. Somebody has opened the YouTube link actually.
Am I audible to all? सूरज जी इसको बंद करो जो आवाज आ रही है echo. There's a lot of echo on my system.
You can start.
बैकग्राउंड में चला गया है.
आपने कर रखा है, मैंने कुछ नहीं कर रखा है.
And it's also getting repeated.
आवाज आ रही है. Echo. There's a lot of echo on my system.
You can start.
बैकग्राउंड में चला गया है. अब नहीं आएगी.
Yeah, I think good to go.
Yes. Yes, sir. Hello and welcome to the second lecture of the SCAORA lecture series for Advocates on Record exam to be scheduled in June 2024. Today's topic is professional ethics, which is the third exam scheduled on 14th of June. I would request my SCAORA president, Mr. Vipin Nair, sir, to kindly come and introduce today's speaker. Vipin, sir.
Good afternoon, everybody. We have carefully selected the speakers for these lectures. And according to me, the speaker today, Guru Krishna Kumar, is the perfect choice because of the highest integrity that he enjoys in the bar. And the topic concerned is professional ethics. As his name suggests, he is a guru. And today we have a lot of shishyas waiting for some guidance. They are slightly tense because the exam dates are coming. But I'm very sure that Guru with his eloquence will fray their tempers and their anxiety. Guru has been an outstanding topper even in college. He has been a phenomenal debater. He has represented India in the international Jessup competition where they came top 8. And later on, he also got the Chevening scholarship and studied in the UK for company law. Coming from such a background, he took to the litigation like a fish to water. He is from the chambers of the famous Attorney General K.K. Venugopal sir and ASG Vaidyanathan sir. And he has been appointed amicus also in the MC Mehta cases. Professional ethics, when we asked him about the topic, he said this is something very dear to his heart. So it is my personal privilege and honor to call Guru to address the wide spectrum of aspirants who are waiting here. Guru, all for you.
Thank you, Vipin, particularly for those generous and kind words. Nikhil, all the other office bearers of the Advocate on Record Association, and of course the aspirants who have logged in today. A very good afternoon to all of you. First, some clarifications. An extremely hot summer afternoon, 3 o'clock. Therefore, please rest assured that it is not going to be one long-winded lecture on the topic. On the contrary, I propose to flag certain important issues, certain important points, and certain important decisions and principles with reference to statutes and rules with regard to advocacy and professional ethics. All of you, I quite understand, are in the middle of very hectic, intense and serious preparation for the advocate on record examination. It calls for tremendous amount of concentration, tremendous amount of industry, and ensuring that you focus on the examination till actually the job is done. And all of you are up to it in terms of your active and focused participation. Now, coming to the topic, advocacy and professional ethics. All of us, or rather most of us in the profession, come across very searching questions when we take up cases. Somebody might wonder, now this is a criminal case. It appears that the person who is accused is perhaps guilty of the offense. Is it right on my part to take up this case? Will I be falling foul of any standards if I take up a cause of this type? We have heard of people saying that I don't take up X type of cases. For example, somebody might say, I don't take up cases on behalf of labor at all. Some people saying appear only for management in service disputes or labor disputes. Some people making a claim that they don't appear in matrimonial cases at all. Some people, let us say in the beginning of their profession, they want to show their presence in the court. They want opportunities to show their arguing skills, but they are not easy to come by. So there are people who volunteer to do legal aid work. Now in legal aid, obviously the payment that is made is something which is nominal. It is not at par with what a lawyer will be able to claim from a private client whom he is dealing with directly. And apart from the fact that there are tremendous amount of gaps in terms of what instructions he might or might not receive, and so on and so forth. Let's take a lawyer who is enrolled to legal aid and has been doing a case. Suddenly she gets the feeling that what is being paid is not commensurate with the amount of work and the amount of time she is putting into the work which has been entrusted to her. A question might arise. That lawyer might ask herself or want to know, is it right on my part to try to make a contact with the client whom she has not contacted at all, whom she is not in touch with at all, and say, can I have some more fees apart from what's being paid through legal aid? Or for that matter, somebody who's taking up a case and ultimately finds that a close relative or even a fairly distant relative is indirectly involved in the proceeding. And therefore a question comes, is it right on the part of the advocate to take up such a cause where the client whom he represents may be in a position of conflict with the relative of the advocate? There are several such instances. Now the question that comes up in all these cases, in all such situations, they could be varied, they could be myriad. Such instances where there are dilemmas, doubts, and queries whether something is right, something is wrong, whether a course of action being adopted is correct or incorrect. Now, are all these instances of moral dilemma or a case of ethics, which really amounts to not following ethical practices? This is really the heart of the entirety of professional ethics. To contextualize the topic, I think the first point which all aspirants, some of you have already had an introduction to the topic by way of some material you may have studied. First thing you might have seen or you're required to see is this. When we talk of professional ethics, we talk of ethics with regard to a particular profession. So the first thing one needs to understand is, when we talk of professional ethics, we talk of professions. And when we talk of professions, we talk of certain clear understanding and well understood principles of what a profession is. You take any textbook on, let's say, tort law, or anything on professional negligence or professional liability, or any judgment of courts, judgment law, or even any other connected material dealing with such principles, 3 or 4 points at once would become clear. Who a professional is? One, a professional is one who professes a special skill, knowledge, and training in a particular field. It could be a doctor, it could be a lawyer, it could be an architect, and so on. Number 2, that professional, the nature of his work is such that it is more mental than physical exertion. In terms of the core work that she does, it is predominantly a mental exercise. That's the second point which needs to be understood. A third point which requires clear understanding is that a person to be accepted, acknowledged, and legally accepted as a professional is that he needs to have certain qualifications, and she has to go through certain procedures which a statute provides for in terms of regulation of their conduct, particularly standards which are laid down by the peers themselves, and there is a regulatory mechanism in place. Fourthly, this is something incidental. The professional enjoys a unique or a high status in the community. Therefore, when we talk of professional ethics, first thing which we need to understand in the backdrop is the fact that the meaning of the expression profession has to be clearly understood. Now, having looked at this, we now come to the question of the profession of lawyers, the legal profession. So far as the legal profession is concerned, one important aspect is this, that the functioning of the legal profession is largely, or I would say substantially, codified, in the sense that the Advocates Act provides comprehensive provisions with regard to how a person will be accepted as a lawyer, what qualifications are required to become an advocate. Number 2, what qualifications he needs to have, or what disqualifications she should not suffer for being enrolled as an advocate. Number 3, the Advocates Act provides for various functions of an All India regulatory body, namely the Bar Council of India. And that regulatory body has enumerated functions that it has to perform. Number 4, the Act provides for what is conduct which is misconduct, and provides a procedure for disciplinary action to be taken against an advocate for any misconduct. Now, these broadly is the structure of the Advocates Act. Now, going to the nitty-gritty, and the reason why I'm getting into the Advocates Act is because the provisions contained in the Advocates Act and the rules which have been framed by the Bar Council of India, they form the core of professional ethics which an advocate has to follow. Therefore, it is important that the provisions of the Advocates Act and the rules framed by the Bar Council are clearly understood in this regard. Now, it would, I think, be beneficial for us to have a quick look at some of the specific provisions of the Advocates Act. Take, for example, Section 49. Section 49 of the Advocates Act makes provision for what the functions of the Bar Council are. Now, if you see Section 49, please take note of the heading of the section. 49 says general power of the Bar Council of India to make rules. Now, what does the section itself say? It says the Bar Council of India may make rules for discharging its functions under this Act, and in particular, such rules may prescribe A, the conditions subject to it, an advocate may be entitled to vote at an election to the State Bar Council, including the qualifications or disqualifications of voters, manner in which the electoral roll of voters may be prepared and revised by the Bar Council. AB, important, qualifications for membership of a Bar Council and the disqualification for such membership. Now, please see AF, the minimum qualifications required for admission to a course of degree in law in any recognized universities. The class or category of persons entitled to be enrolled as advocates. Then the conditions subject to which an advocate shall have the right to practice and the circumstances under which a person shall be deemed to practice as an advocate in a court. Now, please see C, that's so very important, under 49(1)(c). The standard of professional conduct and etiquette to be observed by advocates. Now, this is one of the most important provisions which is required to be borne in mind while dealing with professional ethics. The power of the Bar Council to frame rules in respect of standards of professional conduct and etiquette to be observed by advocates. Please, therefore, recall that this provision is central to an understanding of professional ethics and the codification of the principles in this regard. Now, there are certain other provisions of the Advocates Act also which need to be borne in mind. Take section 24 capital A. That section provides for the disqualifications for a person for enrollment. What does it say? No person shall be admitted as an advocate on a state roll. A, if he is convicted of an offense involving moral turpitude. If he is convicted of an offense under the provisions of the Untouchability Offences Act of 55. If he is dismissed or removed from employment or office under the state on any charge involving moral turpitude. Then there are explanations and provisos, etc. Therefore, this is something which will have to be borne in mind while dealing with professional ethics. Now, one other important provision, which again is central to the understanding of the Advocates Act and while dealing with professional ethics. Please come to Chapter 5 of the Advocates Act dealing with conduct of advocates. It's a very important set of provisions. Section 35 particularly, which talks of punishment of advocates for misconduct. Now, what does it say? Subsection 1 says, on receipt of a complaint or otherwise, a State Bar Council has reason to believe, please note this, reason to believe that any advocate on its roll has been guilty of professional or other misconduct, it shall refer the case for disposal to its disciplinary committee. So therefore, there is provision for making a complaint or even otherwise suo motu, a bar council, where it has reason to believe. So reason to believe is an expression in law which has specific meaning and connotation. That is, there must be satisfaction of the authority, but based on objective material. Now, where there is reason to believe that an advocate on its roll has been guilty of professional or other misconduct, it shall refer the case for disposal to its disciplinary committee. Then 1A talks of how the Bar Council may, either on its own motion or an application made to it by any person interested, withdraw a proceeding pending before this committee and direct the inquiry to be made by any other disciplinary committee of the council. Then 2 talks about the disciplinary committee of the Bar Council, which will hear the complaints. Now, what are the types of punishment which can be given? That will be provided in subsection 3. That says, disciplinary committee of a State Bar Council, after giving the advocate concerned and the advocate general an opportunity of being heard, may make any of the following orders. What are they? Dismiss the complaint, or where the proceedings were initiated in the instance of the Bar Council, directed the proceedings be filed, or it may reprimand the advocate, suspend the advocate from practice for such period as it may deem fit, and remove the name of the advocate from the state roll of advocates. Then the consequences of what happens if a person is suspended. Now, there is section 36, which gives overarching disciplinary powers to the Bar Council of India. That is also to be borne in mind. Then there are other sections like section 36A, 36B, etc. How the constitution of the committee will take place. What about disposal of the disciplinary proceedings? 37 talking about appeal to the Bar Council of India and then appeal thereafter to the Supreme Court of India. And then there are various other provisions, including Application of Limitation Act, which are all procedural provisions. Now, please also remember that there are two other sections which must be borne in mind, which are found in Chapter 4 of the Advocates Act under the heading Right to Practice. Now there, Section 29, which provides that advocates to be the only recognized class of persons entitled to practice law. Subject to the provisions of this Act and any rules made thereunder, there shall, as from the appointed day, be only one class of persons entitled to practice the profession of law, namely advocates. Then 30, which gives the right to advocates to practice. There again it says, subject to the provisions, every advocate whose name is enrolled in the state roll shall be entitled as of right to practice throughout the territories to which this Act extends. In all the courts, including the Supreme Court, before any tribunal or person legally authorized to take evidence, and before any authority or person before whom such advocate is by or under law for the time being in force entitled to practice. Now, this really takes us to the nature of the profession itself. You see, therefore, there is this provision which says that there is a right to practice for advocates, and advocates are the only persons who are entitled to practice as such, the profession of law. Now, this is reflective of the overall position that the profession of advocates is unique. It is sui generis. It is not like any other profession. This is where I want to draw the attention of all the aspirants to a very recent decision of the Supreme Court, which was just made a few days back, practically, I think on 14th of May. Now, the court was concerned with the question whether the advocates in the practice of their profession will be amenable to the jurisdiction of the consumer protection law. Because the argument was that the service provided by an advocate is a service which will come within the meaning of the Consumer Protection Act, and therefore they will be liable to be proceeded against for any alleged deficiency in service under the Consumer Protection Act. That was the allegation made, and the National Consumer Disputes Commission had said that yes, they will be amenable to the Consumer Protection Act. Now, the Supreme Court did not agree and held that the legal profession will not be subject to the mechanics of the Consumer Protection Act. Now, in the process of doing that, what is important for our present purposes is what the court said about the nature of the profession itself. Please, therefore, note that judgment because it's a recent judgment. This judgment is called the exact cause title is Indian Bar of Indian Lawyers versus D.K. Gandhi. Now, this judgment, it's a neutral citation that we have. The citation is 2024 INSC, that is Supreme Court, page 410. Now, the court takes note of what a profession is. That's a paragraph 18. That's one important thing. And dealing with the unique feature of the advocate's profession, there are paragraphs 29 and 30 taking note of it. Now, what does the court say? Some of the important observations of the court, I'm just reading for immediate reference. Advocates are expected to be fearless and independent for protecting the rights of citizens, for upholding the rule of law, and also for protecting the independence of judiciary. Now, court further says, advocates are perceived to be intellectuals amongst the elites and social activists amongst the downtrodden. Please see how the court puts it. Advocates are perceived to be intellectuals among the elite and social activists among the downtrodden. I mean, this is just a reflection of how advocates represent varied interests, persons from across the cross-section of the society. That's what is reflected. Court goes on to say that is the reason they are expected to act according to the principles of uberrimae faith, that is utmost good faith, integrity, fairness, and loyalty while handling the legal proceedings of his client. Being a responsible officer of the court and an important, please note this, important adjunct of the administration of justice. An advocate owes his duty not only to his client, but also to the court as well as to the opposite side. This is very important. Please see the threefold duties. One, duty to the client, duty to the court, and duty to the opposite side. And in para 30, some more pertinent observations. Having regard to the role, status, and duties of the advocates as the professionals, we are of the opinion that the legal profession is sui generis, unique in nature, and cannot be compared with any other profession. This is very, very important to be borne in mind. And the reason why I highlighted at some length this point is because this has to be understood in the backdrop of what provisions and rules have been made by the Bar Council of India with regard to professional conduct and etiquette for lawyers. Remember, I mentioned Section 49 of the Advocates Act. Now, under Section 49 of the Advocates Act, the Bar Council of India has made rules governing advocates. These are found in Part 6 of the Bar Council of India rules. Particularly, if you look at the provisions, Chapter 1 contains restrictions on senior advocates. I'm not going to elaborate on that for the time being, but please remember, this is one of the sections which you need to bear in mind in terms of looking at what the restrictions are under which senior advocates are supposed to function. Now come to Chapter 2. That is one of the most important chapters while dealing with professional ethics, and any aspirant will need to have a clear understanding and a good take on the contents of this chapter. Chapter 2, with the heading Standards of Professional Conduct and Etiquette. Now, it says these rules are under Section 49 1C of the Act, read with the proviso thereto. Please remember, a few minutes back, I read the section itself. Now, note this preamble. I'm sorry that I'll be reading from this because it's a little interesting, because the principles laid down here is something which you need to understand. In fact, my colleagues tell me that a few years back, I think 2018 or 19, the question paper contained a specific question asking the candidates to fill in the blanks by setting out this preamble incompletely. And this preamble really sets the tone for the various provisions which constitute the core of professional conduct, ethics, and etiquette for lawyers. Now, what does the preamble say? It says, an advocate shall at all times comport himself in a manner befitting his status as an officer of the court, a privileged member of the community, and a gentleman, bearing in mind that what may be lawful and moral for a person who is not a member of the bar or for a member of the bar in his non-professional capacity may still be improper for an advocate. Without prejudice to the generality of the foregoing obligation, an advocate shall fearlessly uphold the interests of his client and in his conduct conform to the rules hereinafter mentioned, both in letter and in spirit. Very important. The rules hereinafter mentioned contain canons of conduct and etiquette adopted as general guides, yet the specific mention thereof shall not be construed as a denial of the existence of other equally imperative, though not specifically mentioned. Therefore, these are indicative. These are not exhaustive. And the preamble clarifies that these being general guides, if nothing specific is mentioned, that does not mean that it is not part of professional etiquette. Now, there are 3 sections to this. It's important that candidates recall this and have a good take, because a lot of questions and decided case law is with reference to the provisions contained here. There is Section 1, which talks of duty to the court. Then there is Section 2, which talks of duty to the client. And then there is Section 3, which is duty to the opponent. There is also a Section 4, which is duty to colleagues. In fact, Rule 36 contained there is a very, very important rule, because that deals with whether advertising can be done by lawyers, and if they can spell out to the world what they are doing, under what terms they can do or they cannot do. Now, therefore, if one sees this entirety of the structure of these rules, what you find is that there is at the same time for an advocate a duty to the court. Then there is a duty to the client which he has. And there is also a duty to the opponent. Now, at once, you will notice that there could be occasions where there is seeming conflict between the duty that you owe to the court in comparison to what you owe to the client, or for that matter, even to the opponent. This is where the challenges of ethical considerations and what the standards of ethics that need to be followed become extremely important. In fact, one point you need to bear in mind is this. As I told you, one of the characters of a profession is that it is something where there is self-regulation by the professionals themselves, where there is a body, a regulatory body consisting of peers, and the standards which they lay down are those which are accepted by the body of professionals as something which are ethical and which need to be followed. Which is why if you take any judgment of the court on what professional ethics is, whether a particular case is where the concerned advocate is guilty of misconduct or has not acted ethically, courts have always looked at it from the point, they've looked at the standards from the point of view of the profession. That's why courts have said standards will have to be seen qua the profession. This is a principle you need to bear in mind. Now, coming back to what I was mentioning about the duty to the court, the client, opponent, and to the colleagues. Now, first, it says, while talking about duty to the court, it says, advocate shall, during the presentation of his case, while otherwise acting before a court, conduct himself with dignity and self-respect. He shall not be servile, and whenever there is proper ground for serious complaint against a judicial officer, it shall be his right and duty to submit his grievance to proper authorities. Now, 2, it talks of how an advocate shall maintain towards the courts a respectful attitude, bearing in mind that the dignity of the judicial office is essential for the survival of a free community. An advocate shall not influence the decision of a court by any illegal or improper means. Private communications with the judge relating to a pending case are forbidden. Then, please see 4. An advocate shall use his best efforts to restrain and prevent his client from resorting to sharp or unfair practices and from doing anything in relation to the court opposing counsel or parties which the advocate himself ought not to do. An advocate shall refuse to represent the client who persists in such improper conduct. He shall not consider himself a mere mouthpiece of the client and shall exercise his own judgment in the use of restrained language in correspondence, avoiding scurrilous attacks in pleadings, and using intemperate language during arguments in court. Now, please see the range of duties which are there. Please see the range of expectations which the law expects of an advocate. These constitute the body of professional ethics. Now, there are various other such provisions. Once you read the entirety of section 1, you will see the full amplitude of what duties are which are prescribed under this section. Now, talking of section 2, which is duty to the clients. Now, if you see, some of them are very interesting. It says, an advocate is bound to accept any brief in the courts or tribunals or before any authority, any other authority in or before which he proposes to practice at a fee consistent with the standing at the bar and the nature of the case. Special circumstances may justify his refusal to accept a particular brief. An advocate shall not ordinarily withdraw from engagements once accepted without sufficient cause and unless reasonable and sufficient notice is given to the client. Upon his withdrawal from a case, he shall refund such part of the fees as has not been earned. An advocate shall not accept a brief or appear in a case in which he has reason to believe that he will be a witness, or if he being engaged in a case, it becomes apparent that he is a witness on a material question of fact, he should not continue to appear as an advocate if he can retire without jeopardizing his client's interest. Then, likewise, several such requirements have been set out. Now, what about duty to the opponent? Section 3. That is Rule 34. It says an advocate shall not in any way communicate or negotiate upon the subject matter of controversy with any party represented by an advocate except through that advocate. An advocate shall do his best to carry out all legitimate promises made to the opposite party, even though not reduced in writing or enforceable under the rules. Therefore, this is the kind of wide range of duties that he owes. Now, how does all this translate into actual application when you deal with cases? What is the meaning of this whole procedure set out in section 35, 36, etc., which I read out? talking of professional misconduct or other misconduct. Now, what the aspirants need to bear in mind is the language of 35. Just make a note of it because it's a little important. Number of cases are there touching upon this. Now, if you see section 35, it talks of how an advocate will be guilty of professional or other misconduct. Just make a note of it. If you see, the section says, where on receipt of a complaint or otherwise a state bar council has reason to believe that any advocate on his rolls has been guilty of professional or other misconduct, it shall refer the case for disposal to its disciplinary committee. Now, there are a number of cases which deal with this. You can just make a note of one or two of these cases which I will give. In fact, what I'm going to do is, maybe my colleagues are very helpfully prepared a chart, as it were, of some of the most important cases, some 30 to 35 cases, where the facts of the case have been given and the main important findings of the court and the ratio of the decision of the court. You take, for example, a case called Dastane versus Srikant Shivde, which is reported in 2001. 6 Supreme Court cases, 135. Now it says the facts are like this, very broadly. 2 advocates who were representing a client continuously sought adjournments. This is notwithstanding the fact that there were witnesses who were attending for cross-examination. Now, they gave various reasons, and it was found that on the same day, they were appearing in other cases. Now, the State Bar Council dropped the proceedings. Then, the BCI also refused. What did the court say? Dealing with misconduct, the court said, Supreme Court said, misconduct is of wider import. If advocate has unavoidable inconvenience, it is his duty to make alternate arrangements when witnesses being called by court are in attendance. Seeking adjournments without making other arrangements for examining such witnesses is a dereliction of duties. Such dereliction, if repeated, amounts to misconduct. There are several other such cases. Let's say a client demands money and says he is going to file 2 cases for the client, but files only 1 case. Now, again, he is guilty of misconduct. Therefore, some decided cases. Now, section 24, where a person who is guilty of, who is convicted of an offense of moral turpitude, he will not be qualified to enroll as a lawyer. How do you understand the expression moral turpitude? Because if you see misconduct itself, or for that matter, moral turpitude, these are expressions which are not defined in the Act. So we have to go by the general understanding as judicially interpreted. Now, for moral turpitude, you can just make a note of SBI versus P. Subramani, 2019-18 Supreme Court cases, 135. Now, what does it say? Ordinarily, the tests that can be applied for judging an offense involving moral turpitude are whether the act leading to a conviction was such as could shock the moral conscience or society in general, where the motive which led to the act was a base one, where on account of the act having been committed, the perpetrators could be considered to be of a depraved character or person who was to be looked down upon by the society. Likewise, we have several cases. As I said, there are at least about 20 to 30 cases dealing with various facets of misconduct. And some of them also deal with misconduct which is not professional misconduct. Professional misconduct is something where in discharge of functions as an advocate, there is any misconduct. Other misconduct is the person acts in a certain manner, which is misconduct, even though when he is acting in that manner, he is really not functioning as an advocate. But what is important is he is nevertheless an advocate who is enrolled with the Bar Council, and therefore he is expected to maintain a high standard even in respect of his conduct, which is not in relation to his professional work. Now, there are a couple of interesting decisions in respect of persons who are sought to be proceeded against for other misconduct, but then they are not enrolled with the Bar Council. Courts have said in such a case, Section 35 of the Advocates Act will not apply. Therefore, at the end of this session, through the Advocates on Record Association, what I'll do is I'll give a short note, a compilation of the important cases dealing with the various facets of professional misconduct and other misconduct and how the courts have dealt with it. I think that's the best way, means by which somebody will be able to digest the various nuances rather than going into the nitty-gritty of each case, which will not only consume so much time in terms of the limited time frame that we have, but will also perhaps become a little pedantic. Therefore, this is something which may be of some assistance to all the aspirants. Now, there is one other aspect. Now, the Bar Council, therefore, has the power to take disciplinary action under the Advocates Act. What about the power of the court? An advocate, you remember I had mentioned the recent judgment of the Supreme Court in that case regarding applicability of Consumer Protection Act, spoke about the unique character of the profession and how it said that an advocate is an adjunct of the justice delivery system. Now, therefore, advocates being an integral part of the justice delivery system, they are functioning when we are talking about advocates in litigation practice. We are talking of how appearance in court and the conduct of the advocate before the court becomes an extremely important facet of ethical practice and professional ethics. Now, there have been some interesting judgments. There was this case concerning a very senior lawyer sometime in the 90s, where the allegation was that he had misconducted himself in the court by being extremely aggressive, abusive, and not comporting with his position as a senior counsel while arguing a case before the court. Now, initially, a 3-judge bench of the Supreme Court said this conduct is something which is so unbecoming that his license to practice is liable to be cancelled for gross misconduct. A question came whether the court could take action for misconduct under the Advocates Act because the Act vests and invests the Bar Council with the authority to take action for misconduct. A 5-judge bench, a constitutional bench of the Supreme Court, in Supreme Court Bar Association versus Union of India, please make a note of this, it's an important judgment, 1998, 4 SCC 409, the court said that the function of the Bar Council cannot be taken over by the court. It is for the Bar Council to take disciplinary action in respect of a lawyer for any misconduct. It is yet another thing for the court to take action against a lawyer for contempt of court, where the conduct is such that it really is something which constitutes contempt on the face of the court or against the court. Therefore, this is something to be borne in mind. In fact, another interesting case which needs to be borne in mind is a judgment called Krishna versus High Court of Madras. Now, this judgment is reported in 2019, 16 Supreme Court cases 407. Now, this case also I am giving specifically for one important reason. Now, certain rules were framed by the Madras High Court with amendments being made where inter alia it provided that the court can take action against an advocate for misconduct. And these rules were therefore challenged. The validity of these rules were challenged as being unconstitutional and contrary to the Advocates Act and various other grounds. Now, Supreme Court importantly held that the concerned rule is something which is not constitutional. Please make a note of paragraph 57. I'll just read one or two portions of that because it's a little important in terms of understanding the concept. Paragraph 57 of the judgment says, by amending the High Court rules in 1970, High Court has inserted impugned rules 14A to 14D. The rules have been framed in excess of the power conferred under Section 34 of the Advocates Act. Section 34 of the Act does not confer such a power to frame rules to debar a lawyer for professional misconduct. The amendment made by providing 14A Romans 7 to 12 is not authorized under the Advocates Act. The High Court has no power to exercise the disciplinary control. It would amount to usurpation of the power of the Bar Council conferred under the Advocates Act. However, the High Court may punish an advocate for contempt and then debar him from practicing for such specified period as may be permissible in accordance with law, but without exercising contempt jurisdiction by way of disciplinary control, no punishment can be imposed. As such, the impugned rules could not have been framed within the purview of Section 34. provisions clearly impinge upon the independence of the bar and encroach upon the exclusive power conferred upon the Bar Council of the state and the Bar Council of India under the Advocates Act. The amendments made to 14A to D have to be held to be ultra vires of the power of the High Court. Now, this also I'm highlighting for one important reason. The Advocates Act, as I said, being a codification, is really an attempt to have an organic approach to regulation of the profession itself. Because one of the most important facets of the profession, being a part of the justice delivery system, is advocates should enjoy a certain amount of freedom, independence in their functioning, because they are part of the process to uphold the rule of law. There is an overarching public interest in the independent functioning of the legal profession. This is how the act has to be understood, the legal structure has to be understood, and the ethics have to be understood. In fact, one interesting aspect which all aspirants need to bear in mind is some of the lamps to advocacy which an author had written about. It's a very interesting discussion. And in fact, many of the years, what is found is that some questions are raised or a question is asked about the lamps of advocacy. What are these lamps of advocacy? Now, there is this author, one Justice Abbott Parry, who has written about 7 lamps of advocacy. Just make a note of this, because again, this is a little important from the point of view of understanding the nature of the profession and what should animate consideration of professional standards of conduct and professional ethics. Now, what are these 7 lamps? One is the lamp of honesty. Second is the lamp of courage. Third, the lamp of industry. Fourth, lamp of wit. Of course, we can, as they say, keep talking about necessity of wit and humor in court till the cows get home, as they say. Wit is such an important part of an advocate's armor. Then lamp of eloquence, lamp of judgment, lamp of fellowship. All these are aspects which are so very important for an advocate in her day-to-day functioning. In fact, I would like to encapsulate these lamps in that sense, or for that matter, the guiding principles for an advocate in the day-to-day functioning of her duties and discharge of her duties. I think all that is encapsulated when we talk of standards and all these provisions which talk of etiquette and standards of conduct, we are looking at 3 underlying themes, which are actually, according to me, 3 I's. One is intellect, the second is industry, and third is integrity. I think these 3 are really the sub-theme when we talk of the ethics which need to be followed in respect of the profession. Now, talking of all this, another important aspect which needs to be borne in mind. What about an advocate's right to advertise? Now, we talk of how various people project their attainments. People from various walks of life, people from various trades, from various businesses, from various other fields of activity, they advertise and project their work. Now, what is the position of an advocate? Now, Rule 36 is very important in this regard. Please make a note of Rule 36, which is contained in Section 4, which I referred to when talking about the rules made under the Bar Council of India rules. Now, Rule 36 provides that an advocate is prohibited from soliciting work or advertising either directly or indirectly, whether by circulars, advertisement, touts, personal communications, interviews not warranted by personal relations, furnishing inspiring newspaper comments, or producing so-and-so, which has been engaged or concerned. Even the signboard, nameplate, or stationery of an advocate should not indicate that he is or has been the president or member of a bar council or of any association, or that he has been associated with any person or organization, or with any particular cause or matter, or that he specializes in any particular type of work, or that he has been a judge or an advocate general. Now, please see the extent to which there are restrictions in terms of advertising. Now, one important thing is, in 2008, there was a resolution passed by which there was some kind of a liberalization of this rule, by which you can under Rule 36 now, after the resolution, you can provide some basic information in respect of details of your enrollment, what is your area of practice, etc., maybe in a website or in any other medium. Now, there is also an annexure, a schedule, which sets out the details which can be provided, and it specifically says that any violation of that rule will result in a person being guilty of misconduct. Now, the reason why I'm talking about advertising is very important. Today, we are talking of the profession in the 21st century, where tremendous strides have been made in technology, where tremendous strides have been made in all walks of life in terms of style of living, quality of living, standard of living, and with globalization, opening up of the economy, and so many other attendant features. A question sometimes being asked, are we looking at very archaic rules, all of which have been made long back, which are no longer consistent with or anachronistic to the present day situation? Today, we are talking of social media boom. We are talking of so much of expansion of various technological tools and interventions in day-to-day practice, and how social media presence is so significant and impactful. Even the administration of justice is getting affected. Now, the question will arise in this backdrop: is it right anymore to say that advertising not being provided is not worthwhile? After all, there are some benefits in advertising. The public will get to know what the credentials of a lawyer are. The public will get to know what is the specialization of a lawyer. They get to get some details rather than being just left in the dark to take a choice. But the difficulty is where to draw the line. Is it a situation where some truthful disclosure of what a person can handle in terms of specialization is being provided for, or misleading claims are being made? Now, these are some of the aspects. In fact, there are some judgments in respect of what can or cannot be done in the light of canons of ethics. And again, those judgments will be part of the compilation which I spoke about. Now, we have spoken of all of this. There is also another aspect which needs to be borne in mind. I spoke about the rules under the Advocates Act. There are also rules under the Supreme Court rules framed by the Supreme Court of India. Now, those rules again are similar to what is contained in the rules framed under the Advocates Act. Please make a note of it, because that really is something which is specific for advocates and advocates on record practicing before the Supreme Court. Please make a note of Order 4 under Supreme Court Rules 2013 dealing with advocates. Please make a note of all of this, by which it is important to bear in mind that these rules equally apply for a lawyer in the course of practice before the Supreme Court of India. Now, having now given you the broad structure of the codified law and also the case law that is really forming part of the understanding of how this codified law works, and of course the more fundamental aspect of what a profession is, what the status of the advocate's profession is, and also of course talking about how there are rapid changes now in the society in terms of technological advancements and various other aspects. Therefore, in the light of this, it is very necessary to understand that professional ethics is something which has to be understood as enduring values which need to be followed, notwithstanding the various changes, because they form the cornerstone on which the edifice of a professional's practice and work is premised. There are also certain other features which are a little important to be borne in mind while dealing with this paper. We have adopted the adversarial system. Now, the adversarial system essentially requires that innocence of a person is presumed till the person is held guilty. And there is need for proper and active representation of an accused at every stage of a case. Now, there are instances where, because of poverty, lack of access to resources, an accused is not able to get proper legal assistance. Now, in such situations, courts therefore adopt this methodology of appointing what is called amicus curiae. An amicus curiae, literally translated, is a friend of the court. Now, amicus curiae has a very unique position where he has to ensure that the interests of the accused are represented in the best possible manner without sacrificing the duty to the court. In fact, there are 2-3 important judgments of the court which deal with this idea of amicus curiae and what are the circumstances under which an amicus curiae ought to be appointed. You can just make a note of one of the recent ones, Anokhi Lal versus State of MP, 2019, 20 Supreme Court cases, page 196, where the norms for appointing an amicus curiae have been set out by the Supreme Court. Now, therefore, in the light of all of this, what needs to be understood is that professional ethics are the most fundamental foundation on which day-to-day practice of a lawyer depends. And it is very essential that there is a clear understanding of what the ethical standards are and whether any particular conduct falls on the right side of the standard or on the wrong side of the standard. In fact, one practical tip which I want to give before I wind up this discussion, if you look at the previous year's papers, there are some topics which repeatedly get attention in the question papers. Please bear in mind, some of these topics are these. 1, what about the power of the Bar Council under Section 35 and how does it comport with the powers of the court for contempt? And how is there an overlap, or how do the two jurisdictions function? 1, what is the position of an amicus curiae? What about the 7 lamps of advocacy which guide the functioning of a lawyer, and what is its relevance to the present day? What about fair criticism of a judgment or a fair comment by a lawyer? In fact, 2 important things I think we should bear in mind in this regard. Now, there are cases today, ongoing cases, pending cases, which are widely discussed and debated in the media. As I told you, social media today has become so impactful, and the presence of social media is so huge today. Any sensitive case, particularly political cases, they all get discussed so fully and so extensively in the media. A question may arise: is it right or not for an advocate who is appearing in any such case to go and discuss the merits or demerits of a case which is sub judice? This is one of the most important aspects which one should bear in mind. Now, there are questions which are repeatedly being asked on that. Now, ethics would demand that a person who is appearing in a case ought not to go and discuss the merits or demerits of the case in the media when the case is ongoing. This is one thing which needs to be borne in mind, because this is subject matter of questioning almost repeatedly. There is another aspect: strikes by lawyers. Now, lawyers, as I said, are part of the justice delivery system. In fact, historically speaking, most of the notable freedom fighters were persons with a legal background. They had legal qualification. And that's one unique feature of the Indian freedom struggle. So they always did not hesitate to voice their concerns and voice their protest when the situation so demanded. The question is, today in the modern day setting, is it permissible for advocates to go on a strike? The answer is a clear no. Some of the important judgments are Dr. Harish Uppal's case in 2001. Then you have more recent judgments which have dealt with it. Now, these are all cases which provide that. In fact, Uppal's case sets out the parameters of what kind of protest can be undertaken by lawyers. They say the exceptions to lawyers not engaging in strike is only where the integrity of the profession, the administration of justice are all impaired. Then probably lawyers can protest, that too in a symbolic manner. Please therefore make a note of this judgment, because it's very important in terms of understanding the position of lawyers and in terms of repeated questions being raised in respect of this aspect of the matter. Hari Shupal versus Union of India, 2003, 2 SCC, page 45. Now, therefore, this is again another important aspect which repeatedly gets questioned about. Then, of course, questions are asked on duties of an advocate to the court, to the clients, and to the opposing counsel, and various such connected aspects. What I propose to do, therefore, is in the light of this overall introduction to the topic, this note on the case law and some of the important topics which are repeatedly subject matter of questions, I will circulate to the Advocates on Record Association and would hopefully be helpful for all the aspirants in terms of further understanding and reading of the subject, so that you're able to deal with the examination with greater confidence and will be able to come out with flying colors. Thank you very much for listening to this patiently, and I hope this will be of assistance to all of you in your preparation for the examination. Thank you.
Thank you so much, Guru Krishna, sir. It has been an honor to have you as a part of today's lecture on professional ethics. And you referred to the latest case laws, which is really important, as the aspirants are expected to write the latest ongoing in the market in the exam paper. And the compilation in the short note which you have mentioned, we'll certainly have it from you and share it with the aspirants from the office itself. I would further like to extend my heartfelt gratitude to Mr. Vipin Nair, sir, the president of SCAORA, and our executive committee secretary, Mr. Nikhil Jain, sir, and the whole executive committee. I wish all the best to all the aspirants and who will be appearing this time. And with that, I would like to ask if there is any questions in the chat box. So there is one question here in the chat box, if I may read it out for you. Writing rule should be in serial order in exam, or is it as it is in Bare Act?
Can you come back again on the question?
Sir, somebody has asked, writing rules should be in serial order in exam or as it is in Bare Act? What question is
No, in the Bare Act,
Can you-
it's found in seriatim, no? In the Bare Act itself, it's found only in seriatim.
Right,
Good
right.
one.
So
It's not quite clear what the question is, though. It's obvious that it's really in seriatim that the rules are themselves set out in the Bare Act.
Sir, possibly you have covered all the topics today. Therefore, there is only gratitude on the chat box. There are no questions today, so you have really covered it all.
I'm very happy that this initiative has been taken by the AOR. Year after year, AOR Association has been doing this. It's a human service, because the quality of the advocates on record makes such a significant difference to the quality of the practice and the assistance that's given to the bench in the ultimate adjudication of cases, that too in the highest court of the country. And that becomes the law for the whole of the country. And I really appreciate the office bearers for this initiative. And I must also thank you people for giving me the opportunity to be a part of this exercise. And I wish all the candidates all the very best in their endeavor this year. I'm sure all of them will come out with flying colors. Thank you.
Thank you, Guru.
Thank you.